Welcome back to our criminal law coverage. Today we're bringing you a special report on the Shah Diddy Combs case. Right now, we're live from the federal courtroom in downtown New York, where the issue of Shah Combs' bail is being discussed. As we know, previous judges have denied Shah's bail request, but this is the first time the current judge is overseeing this case. Judge Run Subber Manon is the one making the decision on this issue, and we are seeing back-and-forth exchanges between the prosecution and defense regarding bail. What's interesting here is that there are no cameras in the courtroom, but our reporter, Elizabeth Milner, is there and will be stepping out to share what she's seen and heard. For now, we're providing you with live, real-time updates on what's happening in the courtroom. Now let's dive deeper into the interesting developments. Shah Combs' defense attorney, Alexander Shapiro, is engaged in a back-and-forth exchange with the judge overseeing this case. First, Shapiro cites the Trump case, arguing that the defendant has the right to speak more than their lawyer, and mentions Shah's Instagram posts as an example. The judge inquires about Shah's communications from the Metropolitan Detention Center, MDC, and Shapiro responds that the prosecution has racial motives. The judge then asks for clarification on Shah's phone calls and whether he's orchestrated a social media campaign through his family to influence the jury. Shapiro continues to defend the defendant's right to free speech, asserting that Shah's messages and Instagram posts are not instructions to lie. He explains that Shah merely wants to respond to the negative media coverage and has the right to do so under the First Amendment. The judge further questions why Shah didn't go through his legal counsel before making these statements, and Shapiro replies that they are willing to do that, but that it's not the job of the lawyers to control every aspect of the defendant's actions. The debate continues with differing viewpoints on whether Combs is creating a social media campaign to improperly influence the jury. Sean Cole's lawyer, Tenny Gago, mentions that there's a message from Combs requesting to testify, and he will provide this information under seal. Prosecutor Foster may be aware that this doesn't lead to obstruction. The judge then asked about communications between the defendant and witnesses. Attorney Shapiro said these communications were legitimate and there was no issue. The judge continued to discuss these communications. Another attorney for Sean Cole, Mark Agnifilo, mentioned that the first witness had contacted Column's counsel and requested a lawyer, but they did nothing in response to this request, as it was a strange one. The judge replied that they couldn't be certain whether this request was valid or not. Tenny Gago said that there is a message from him to testify, and I will provide you with this information in a sealed form. Prosecutor Foster may be aware that this does not lead to obstruction. I don't have the actual message. Brian, I will begin with you about the back and forth here regarding whether his media activity constitutes obstruction or whether his initiation of a social media campaign is aimed at inappropriately influencing the jury. All of this revolves around the issue of whether he poses a danger on the outside, whether he is disregarding internal rules. He should not be released. What are you drawing from this back and forth? I have experienced the reality that they are debating whether this seems beneficial for him, just like you. Our judge here is trying to provide a fair analysis for all of this, and this is a clash between First Amendment rights as far as I'm concerned, and certain requirements for bail conditions. If granted bail, you are not allowed to contact witnesses. You definitely cannot threaten a witness, but you can defend yourself and marshal, provide a defense, and express your thoughts as the defendant. Judges always face great difficulty in trying to balance these two constitutional issues. This judge is struggling with it because this is a man facing life in prison. His freedom has been taken away, and he is fighting back. and that would be something one might expect from a person accused of their crimes. So I think today may be the first opportunity for a healthy debate on why he should be released. Bradford, I would like to give you an opportunity to respond to that. I also want to update you with another development, where Miss Gagos, once again one of Shan Cole's attorneys, says that her client complies. For instance, with victim 3, he stopped using ASAP and other phone lines. The messages with the first witness were before the arrest. He complied with us. He went to New York to the Bureau of Prisons when I told him not to do something, which he did not do. In other words, if you are concerned about him disregarding the rules, he will listen to us. We will tell him what to do. What do you think? I think that is an argument I often make, and I believe many defense attorneys make the same argument that our clients will listen to us if we tell them what to do and not to do. When you have a case like this, where every day something new gets revealed, something gets leaked by the government or an interested party or someone who cares about the case, it can impact the jury. I think you know that the person who released that Cassie tape, and I keep coming back to the release of that tape, I think it was released because they knew she would be blamed for the events that took place, that she would get involved with these different individuals, and they wanted to make sure that was removed and essentially turn her into a victim, not a co-defendant. I think that's why the tape was eventually leaked by whoever leaked it. A lot does not go back to the issue of how that tape was released, and no one really discusses how the tape was released. And I think that's an interesting point, especially when you have a judge who cares about your story and a prosecution that cares about why he is making these moves, such as public relations strategies on social media. I think it all comes back to that tape, and I think that is their strongest quote, their strongest piece of evidence from their star witness to say, hey, this guy is a bad guy. I like that fact, and I would agree with Brian that the fact that they're talking about it, that the judge is engaging with them, is always a good sign, you know, Beal, that he might grant bail. I don't know, I think this is a tough hill to climb. I think it's a hard battle anytime you have an individual facing the kind of time they're facing and the charges they are facing to get a bail. The bond package is quite extensive in my opinion. A $50 million bond is not something to sneeze at. And diving into one of the areas I think Judge Subramanian seems receptive to is the fact that he told the prosecutors earlier this week to be prepared to talk about this. It's coming up right now, Brian, I'll ask you about this. So Shapiro, whose lawyer for Shan Cole, says that I've filed accusations in the Jeff Abami case, which is even worse than him here. They are accusing an international sex trafficking business, claiming they were raped and forced to participate, and I won't say more, but there is a certain type of sexual behavior involved. And by the way, the argument here is, and this is what Judge Subramanian said regarding prosecutorial authority, why Shan, after offering a bail package, as we said, of $50 million with 247 private security companies, restricted access, no internet use, no phone use. Why did he reject bail while you have Mike Jeff, the former director of AB & Fitch, who was just arrested and charged with sex trafficking? Why is he granted bail with only a $10 million bond? By the way, the prosecution responded earlier, and they had back-and-forth arguments on this issue. He is 80 years old, Sean is 55. Shan Coles is charged with extortion, but he is not charged with extortion. Shan Coles has been accused in previous cases of violent behavior, but not in Mike Jeff's case. But here you see, Brian, where they say they actually think Jeff is worse. What do you think about that? It's amazing, and I think that's the path they have to take because it's precedent. You know, you can't have different rulings for cases with similar views. Discrepancy in treatment is always opposed in federal courts, and here they have a case with a significant public interest. where the bail is set at $10 million according to the agreement. Now, we turn to the Sean fraud case, and they are opposing 5 times the amount for someone who I don't believe has ever been convicted of a federal or felony charge. I could be wrong about that, and they are presenting restrictions that make the previous bail package seem insignificant in comparison. So, they are right in making this argument. It's precedent within that jurisdiction, and I think the judge will review this carefully. You know, right now you have 2 rulings against him, so he has to consider those rulings and the judges who made them, but he also has a situation where the government agreed to bail in a situation that, if not worse, is quite similar to the charges. Look, I think they are doing the right thing. You know, this is also a different court. This is a different court. This is the Southern District of New York, the Eastern District of New York. But even if you put those differences aside, this seems to be one of the most convincing arguments made by the defense. Bradford, by the way, we are also taking questions. So if anyone has questions about this case, please send them in via YouTube. If you have any questions about the hearing, send those in. We have this interesting question from Sahara Useri on YouTube. Why did Combs get a new judge? Why do you think a case like this would be reassigned? Why is it now in the hands of Judge Aaron Suberman? And why do you think this is happening? Bradford, well, in federal cases, we usually seem to start with a judge. That judge is typically the one who first hears the case. If it's a bond issue, or even a preliminary matter, often a district court judge will give the judge authority to decide various motions, including motions to dismiss. Normally, you would meet the judge first, and these judges are usually assigned randomly. After that, another judge may take over the case, but this is not a big deal. I really wish we had cameras in the courtroom, but based entirely on the arguments we have seen and are seeing with Judge Subranian, I can confidently say that this seems like a very fair reason. This judge really puts pressure on both the prosecution and the defense, which is really something to note. This is exactly the type of judge you want in such cases. We also received a question from Samian on YouTube, asking why the prosecutors haven't referenced the R. Kelly trial. They may not have mentioned it today, but it is part of their record. I think even in the initial bail record, they referenced the R. Kelly case and Jeffrey Epstein's cases to justify bail for Sean Coles. Another question from a user, Europe's Hunar, on YouTube. If Diddy is granted bail, does that mean he will be released immediately? This process will likely happen quite quickly. He will have to return to the detention center, and there will be some paperwork to complete, but I think it will happen fairly fast. It could be tonight unless some issue arises. For a high-profile case like this, they will quickly resolve things for the public to see the outcome right away. I think this will happen quickly, definitely tonight, if the judge decides tonight. Some judges may recognize that there will be an appeal of this decision and will take time to issue a written opinion, and that will be the only reason I think the judge might hesitate before making a decision. But overall, this judge seems like someone who is really fair and thorough, and that is his reputation. We also have another update from the court. Once again, Shapiro, the defense attorney for Sean Coles, emphasized that even though the defendant Jeff is 80 years old and the other defendant is 71, Sean Coles is only 55. I hate to say that he is no longer young, but this is one of the things the prosecution mentioned, saying that you're dealing with an 80-year-old man, but you're dealing with a 55-year-old man who is much younger and more dangerous. The judge has said that the U.S. may not adhere to these bail conditions, but Shapiro argued that these conditions are even stricter than being in prison. What do you think about this, Bradford? I think the argument between an 80-year-old and a 55-year-old will not have a big impact on the judge. An 80-year-old man may be willing to do crazier things because he has lived a long life and might feel like he has little time left. When dealing with an 80-year-old, that person might be facing a life sentence, so if convicted of only 5 years, They feel they have nothing left to lose. And he is 85 years old, no longer young, so I think the argument about age isn't that strong. A stronger argument might be in the RICO charges, where they're accusing some form of violent behavior. This could be a stronger argument because the CEO of Abercrombie & Fitch does not have a history of violent accusations or involvement in violence, but the charges about sex trafficking are very, very serious. And in my opinion, they are far worse for the CEO of Abercrombie & Fitch. It's quite interesting that these cases are happening almost simultaneously. If they weren't happening at the same time, there would be nothing to compare. You'd have to go back to another prostitution ring in cases where no one gets bail. Coincidentally, this works out for Sean Coles, as the Eastern District reached a deal with the Abercrombie & Fitch CEO, and that's beneficial for him. I think you have to put a lot of trust in this guy who could escape at any time. Not just because he's a danger, but also because he poses a flight risk. They argued that he could flee at any moment. He has his own jet, he could go to Mexico, he could go anywhere, and he never does. He surrendered when he was supposed to. In fact, they didn't even allow him to voluntarily surrender. They picked him up at night at a hotel, knowing they could call him, and he would surrender the next morning. I think that shows a lot of clear bias from the U.S. Attorney's Office, and I think a judge like this, who was once a clerk for a really good judge and worked in the world of business, would view things in an objective way, which is really beneficial for Sean here, because many other judges could be jaded by the criminal justice system and might not treat him fairly like this judge does. This judge is relatively new to the bench, so I think the advantage that Sean has here is quite interesting. Now I want to read you the latest update from the court. The judge asked where Mr. Agnifilo would be staying, and Agnifilo replied that he didn't want to provide the address, but mentioned it's on Star Island, with a raised road. This is in Miami, Florida, and there's a dock but no boat. The judge responded saying that this wouldn't be effective, as we are in New York. Agnifilo said, "Wait a minute," and then came back saying that there's an apartment on the Upper East Side with a 3-bedroom unit. The judge asked, "Where will the 24/7 security be?" Agnifilo replied, "It's Patriot Security, which has merged with Crisis 24. So Brian, is this just the judge fully exercising his responsibility to understand what bail will look like, or is it a sign of where this case might go? And by the way, we have another update. Agnifilo said there will be 2 security staff in the apartment and 1 on the lower floor, for a total of 3 people. They will not be allowed to use phones or the internet, except for calls with the counsel arranged by the security staff. This is certainly going to have more details to come." It's more restrictive at MDC, Brian. I think the judge is leaning toward releasing him. The judge's response regarding jurisdiction is very important. Most courts, no matter where you are, if they decide to release you, they will release you to that district. So I was a bit surprised that the initial bail package didn't specify that because no one wants him going to Florida. But I think this judge is seriously considering releasing him. Think about it. All the headaches will disappear. We don't have to worry about FDC. We don't have to worry about what's happening at FDC. And we don't have to worry about the counsel complaining in the next 9 months that they don't have real access to discovery, that the defendant didn't get discovery, that the defendant didn't have an opportunity to self-represent with counsel. All those issues will go away if he is released. As a judge, he won't run away. And if they're right, and he's foolish enough to engage in threatening behavior while on release, that will be the first evidence they present at trial. So I think this judge is quite smart, and I think he realizes that the original bail package is something they should seriously consider. You know, he's presumed innocent in this case, and the right to be presumed innocent suddenly disappears when we talk about famous people. But he's still presumed innocent, and the right to bail applies to those presumed innocent, and he is one of those. From the prosecution's point of view, if he is released and engages in obstructive behavior, they could not only revoke his bond, but also gather more evidence to bring an amended indictment with more evidence at trial. But the downside is they don't want to be in a situation where witnesses are threatened or intimidated and refuse to cooperate with the government. So this is a pretty tricky situation. We have an update here. Bradford, I'll turn it over to you. Agnifilo said Mr. Combs will avoid any contact with potential witnesses. I think he has the right to do that, but I want to make things as easy as possible for the court. We will thoroughly investigate before the May 5th trial date. He has the right to assistance. Your thoughts? As I said earlier, I think all the arguments they make fall on ears that are listening, not on deaf ears. That's whenever you're a defense attorney, and Brian knows this as well as I do. You're representing a public figure. Sometimes there are inherent perceptions, and judges are not immune to them. They might release him on bail, this seems like a fair shake, but in the end, they decided in this case, when the arguments were happening and his lawyers were adding to the bail package that he would not contact anyone, he would not have any phones. Many times when I have high-profile clients in federal or state court and I provide 24-hour protection, I usually hire FBI or DEA, and I'm sure the security company he has is probably doing the same. This company will provide reliability to the security forces that will monitor him, ensuring who is checking in and out and signing out and similar things. All of these factors come together in the judge's mind to assure them that they're doing everything possible to keep him out of trouble. I really think that hearing what's going on, the judge is seriously considering allowing him to be released, which to me is a surprise. Because many times in federal court, you don't get treated fairly. When you have these kinds of charges, and you're representing a high-profile person, often these judges will make very difficult decisions. And I think his defense lawyers are doing an excellent job presenting this bail package and explaining it to the judge. Sometimes you find yourself working on the move, where the judge says that this won't work. Florida won't work. I need something else. And it's like, yes, I have an apartment on the Upper East Side. It's a 3-bedroom apartment. We'll put him there. That's not easy to do, but it may help shift the judge's perspective on him. Because when they present those options and can modify their argument that way, I honestly think that when a judge starts asking questions like that, it really means he is very much inclined to grant bail. It's great to be a millionaire because you can just say, oh, where am I? Where is this case happening? Right, I have a property just down the street. Let me ask you this. The prosecutor made a point earlier. They said we're talking about the security team. They said, so the judge asked, what kind of security team are we talking about? They hinted at an accomplice, someone whose phone was taken just one day before. Really, this relates to a defense investigator in this case. That investigator went out and contacted witnesses, basically working for him. So, the reason I bring this up is because the judge just said that the government is claiming that Mr. Combs will pay these people. The issue is whether they can trust what Mark Agnifilo, once again Sean from the defense counsel says, is a different relationship. There are experts who will only show up in his life. In the past 8 months, this has been a high-profile case. He keeps saying that he's been in jail for 66 days without a laptop and only just received one a few hours ago. The unique thing here is that it took 9 weeks to get a laptop into MDC. The judge said the solution is that he has to come see me, and we can call these hearings to sort things out. So that's a separate issue regarding the resources he has. The question, of course, is, Brian, can you trust the security team? The prosecutors say, A, they have connections to him, but B, even if they don't, he still has ways to compromise with people if he's in jail. If he's in jail now at MDC and using a prisoner's phone to make calls, the question is, can we trust the security team? What do you think about that? As my great colleague just pointed out, the solution is to make sure you've explained to the court that you have an impeccable team. I'd be surprised if it's not like that. They should have former FBI, former New York cops, Someone who, when the judge hears bona year A, he'll say, this is someone who has intellectual honesty, someone who wouldn't risk their reputation for a day's pay. So I would expect that if the judge grants him bail, he'll want to see that. He won't want just someone on this guy's payroll supervising him. In these 9 months, I can assure you, I'd be surprised if it's not the case, right? And knowing Mark, like I do, as an excellent lawyer, they'll make sure that's the case. If they've provided a team, they'll get a better team if that's the issue with the judge. Let me ask you this, Brian. I'll ask both of you this because it's a question we get from one of our YouTubers daily. Who pays for the security company? If Diddy pays, is that a conflict of interest? I'll let either of you address that if Bradford you'd like to address it, sure. Yes, because I'll add that it's a great question, and what I do is eliminate the odor of any potential misconduct that might arise. I think it's fine if 24-hour protection for 8 months costs $250,000 to $350,000, whatever the amount. And I guide my clients to send that money to my trust account and/or to a company hired to pay them separately from the defendant, so they don't have to rely on the defendant to pay their wages. This alleviates that discomfort. I mean, there will always be some discomfort like, I'll give you an extra $1,000 if you do XYZ. But you can take one of the links in the chain and say, they'll get paid through ADP or from my law firm, but they won't rely on the defendant for their salary, and they can't be threatened with things like, you won't get paid unless you let me use your phone several times. This is also useful in situations like when the judge asks how this will work with this 24-hour security force, and they'll have to comply because he's the one paying. I think this will eliminate one of those links and also help with the court's decision, making them feel more confident about it. Brian, I'll give you a chance to respond to that. But we also have another update from the court. Mark Agnifilo said, I've prepared the full presentation on the recordings, but if you have enough information, I can save everyone 15 minutes. The judge said, I've reviewed it. Who's here from pretrial services? Pretrial services steps forward and says we're maintaining the conditions as insufficient. The judge said there are other cases where private pretrial security services are used, not just what you think, Brian. It always happens like this. Pretrial services work very well, but they are a government agency, and in cases like this, the default position for pretrial will always be detention. It's just easier for them to handle it that way. The judge knows that one of the other things that came to mind when I was listening to Bradford is, I wonder if the government has harmed itself by searching the prison cell at the wrong time. Yes, they allegedly reviewed privileged documents, which is not allowed, and I don't think the judge is happy about that. And I think he started calculating in this case and thinking, it might be easier for everyone, including the government and the prison officials, if we let this guy pay a lot of money for a private security company to, prevent him from escaping, and we will solve this case. This would make it timely. I wouldn't have to run to court every week or two with complaints about discovery that he hasn't received his laptop. We have terabytes of data to process, and we don't have the capability to protect it. It creates a lot of issues in a case that could easily be resolved by agreeing to a bail package. So that's just another thought, and Brian is 100% on board with this. Yes, he's absolutely right. First of all, there have been cases in New York. I've had cases in New York where we recommended private security and were granted private security. Across the country, when you look at these high-profile cases, there are many instances where private security was used, like the NBA guy who had a case in Louisiana. He was granted private security in Utah. Kodak, whom I represent, was granted private security in Utah. This has happened many times. This has happened many times. And I think the most important thing is that Brian is absolutely right about the government being foolish in searching his cell. They couldn't help themselves like that. Sometimes, they can't help themselves even when they feel they have good cases. They always want more. To be fair, they said that the MDC sweep was thorough. It wasn't just aimed at Sean Combs. His defense team says that it's an excuse. But just to give you another argument, I've got a really cheap bridge to sell you. Listen, I think he was a target first. I find it very hard to believe that there wasn't an expert there who is normally not present, who was taking photos of items that had nothing to do with what they were searching for, phones and drugs and things like that. I find it hard to believe, and sometimes it's shocking when you look at the government when they have so much power, so many resources they can use to get a guilty verdict, and they always want more. They always want more. And in this case, I think this will come back to bite them. I think the only reason this judge is not being unreasonable, I'm not saying he's being very rational, is that the judge has considered some of these arguments, and they didn't fall on deaf ears. Part of the reason for that is because the prosecution, was dreaming that this was just going to happen, and they didn't intend to take his notes. And even though we had his notes, we had a group of us set up a Great Wall of China. They have every excuse in the book, but once you stain a case with something like that, it's hard to regain the judge's trust, and I think that's why so many questions are being raised for the prosecution. And additionally, with the guy who caught the CEO of Fit 2, I think a lot of things have come together for Sean to give him this opportunity, and this is his best shot. So we have another update from the court where the prosecutor has now come forward and said to consider the first witness who was involved in several strange cases. The defendant continued to contact the first witness after the board was held back. The Instagram post was planned for a week by immediately contacting me and other prisoner codes. It's really, really interesting, basically suggesting that Sean Combs is engaging in obstruction. I want to ask you, we have a question from one of our viewers that I think is quite interesting. And Brian, I'll throw it to you. Are there any additional bail conditions the judge could impose on Sean Combs? Could the judge place Sean Combs under the supervision of the Federal Bureau of Prisons? I've never seen that happen. I mean, anything that the Bureau of Prisons can do is insignificant compared to what the defense has submitted. You put an ankle bracelet on someone. I mean, they don't have the resources to have 247 guards at the U.S. Bureau of Prisons, and more importantly, that's not their role. So, a fair question is, why not let the federal government protect and supervise him when he's out? That's not how the system works. And more importantly, I think about all of this, and there has to be a way for someone to self-defend. What we are seeing here is that the prosecution seems to be relying on his attempts to really self-protect. He is seeking help, trying to arrange witnesses for Marshall, finding ways to connect with allies, reaching out to friends and family on social media so he can start not winning the battle, but just trying to make the context a little easier, and even more than that. So, I don't know what the judge will do, but I'll tell you from a constitutional and legal standpoint, the easiest thing to do is to allow this package to be implemented. And the worst that can happen to the defendant is if he spits in the court's face after the court hands this to him. Yes, and by the way, that brings me to another point. So Bradford, we have an update from the court. The question becomes, what exactly was he accused of doing while at MDC? You can exchange back and forth about whether or not he really engaged in obstruction, and his message content compared to whether he just violated the prison rules. If they told him not to make calls or they told him not to do this, regardless of the content, if he violated the rules, the idea is that he violated the Bureau of Prisons rules. What makes you think he wouldn't violate the terms of his release? The reason I say this is because the prosecutor mentioned that his family, a family member said that the lawyers told him not to do that. And the defendant replied, "I don't care. It's my birthday today." This might be related to the entire social media campaign surrounding his birthday and birthday videos. So, the idea is that he didn't care. He violated the BOP rules. The judge said that Monsieur Shapiro argued sharing codes was common among other prisoners, and this behavior is protected by the First Amendment. The prosecutor argued that the Bureau of Prisons manual prohibits this. So the question is whether the actions he took were a violation of rules, or if he was just blatantly breaking rules. If he's simply violating rules without a valid reason, should he be granted bail? The rules he violated are common violations, such as three-way calls and using someone else's PIN code. I don't know how many times I've experienced clients using another person's PIN during three-way calls. While this is a violation, I wouldn't call it a serious offense. This happens so frequently that I don't consider it a serious violation. The government is exaggerating the issue. Unless they can prove that he's using this to contact and threaten witnesses, otherwise, I see this as a minor violation, which shouldn't impact whether he should be released. This is a question from Jasmine Milan on YouTube. She asks whether the defendant can allow family members to do things he isn't allowed to do. If he is released, can he avoid doing the same things? He will do everything possible to protect himself, whether inside or outside of prison. If he's in prison, he has to overcome all the barriers to communicate and protect himself. Let him defend himself. Take off the restraints. Bradford did the right thing. I think I've received 4 three-way calls throughout this session. For God's sake, this is happening. There are probably about 20 of them from this detention center while this is going on. This happens every day, and it goes back to that center which I keep thinking about. This judge seems like a really smart person. The headaches here stem from the fact that his freedom was taken away before the trial even started. All of this headaches, one by one, are set aside for the purpose of debating the government's concern about the threat of each of those headaches regarding AER and the defendant in terms of constitutional protection disappearing. Yes, all the court's headaches in monitoring this disappear. They become someone else's problem, and knowing that if there is a problem, one problem, someone walks by, a little bit, someone calls somewhere, right? He was arrested within 5 minutes of that incident. It's easy to do here, and I've been saying this for a month, to give a guy a bond package of $50 million. I'll ask you another question. Brian, because you're right. We've been beating the same drum a little. I have another question for you from one of our viewers before I get into that. Let me update everyone on what's going on in court. The prosecutor says the defendant used at least 8 inmate codes. He bought them. The judge says they say contact me immediately, operate through real links. The trustee system, restricted inmate computer system. The prosecutor says that's not allowed in Jeff's case, a detainee, and the judge says it's a foreign citizen, okay? So let's create a little difference here. I have another question for you. Brian, if I can find it. This is from Latoya on YouTube. If he's convicted and sentenced to prison, what happens with civil lawsuits? Civil lawsuits could all at some point become indefensible, once he's convicted. Again, make sure all those civil lawsuits related to the charges here to the point they become indefensible. There will be a conviction that will be an integral part of the evidence in the civil case. He will have to be disqualified if he is disqualified while his case is being appealed. He'll have to assert the Fifth Amendment. The Fifth Amendment is the admission in a civil case. Those cases, if they relate to this incident and he's convicted, become indefensible. Another update, the prosecutor says this is similar to cases where a detention order was issued when talking about R. Kelly, Keith Raniere, Larry Ray Bradford. If you're sitting in the courtroom and you represent Sean, and the prosecutor represents you and mentions others, R. Kelly was charged with sex trafficking and extortion, how do you distinguish Shan Combs from those cases? The funny thing is, and it's not that funny, is, different areas have issues with bond and how bond packages are carried out. In the case of R. Kelly, I don't think the number one thing is they set a $50 million bond with no 24-hour security, no electronic monitoring, seizing his phones, computers, etc. They didn't have any of that. So, If you want to compare apples to apples, I think, and in my opinion, the best scenario is the Abercrombie and Fitch CEO. I keep going back to that issue. It happened very early in that time. It's in an area right next to New York City. It's the Eastern District. He was allowed to surrender. He was given a $10 million bond. No one knows if I were in a room with the CEO of Abercrombie and Fitch, I wouldn't distinguish him from anyone else, right? If I were in a room with Sean Combs, I'd recognize him immediately. So, it's a bit of a different situation. Abercrombie and Fitch's CEO could disappear to Morocco. No one would recognize him. I mean, have you seen his face? He has a fairly recognizable face, but that's another issue. I do. But ordinary people don't know who the CEO of Abercrombie and Fitch is. I think Sean Combs is quite well known worldwide, especially even at this point in time, and I believe that helps him stand out compared to the other individuals. We always say, money can do this or money can do that. And it's true, someone without influence might not be granted bail in this case. But that's the whole point of bail. It shows your commitment to appear in court, not violating certain rules to do certain things. When you have more money, obviously the higher bail amount makes it more problematic. For example, someone worth $100 million. If I put up $50, that really wouldn't hurt me, right? It's like, if someone has $100 and they put up 50. So the issue is that the difference between Combs and other cases is that his bail package is completely different from what is offered in other cases. And the fact is, I can't get past the truth that he was just hanging around there. He wasn't going anywhere. It's not like he could leave. I'm sure the feds were watching him 24/7 before they filed the charges, but he was just hanging around there, not going anywhere. He had informed them about where he was flying, when he was flying, where he was going, and when he was going during that whole time. And then, when he knew he was going to be arrested, he flew to New York to prepare. And instead of allowing him to surrender, as they would allow anyone else, he was there to surrender. Instead of allowing him to surrender, which a judge would look at favorably and say, oh, he surrendered, they went to his hotel and they picked him up at 9 p.m. To me. That really is a slap in the face. And I think the reason they did that is because they knew Sean Combs was trying to organize this public relations operation and trying to create a good story about, hey, listen, Mia Kula, I didn't mean anything in that video, and I'm going to rehab and all these good things for his case. I think they were frustrated because the perception started to waver a bit, and then the Cassie tape came out, and the perception went down. Because once you see it on video, it's hard to then see all your friends abandon you. So, I just feel disappointed when you have a guy who's willing to do all this, and you're still, not wanting to agree to bail. So I know we've held you for a while. We'll take a break before doing that. I want to give you some final thoughts. But I want to give you some updates from the court. Brian, I'll start with you on this issue. The judge just said, I suggest both parties send a letter by noon Monday regarding the type of communication Mr. Combs can engage in. It's interesting to think about what he means by that, whether he will be allowed to go out or not. But his attorney, Tony Rico, said, we need to send an email in a week to get him a file. Then he said that his grown children are ready to comply. And he's not a lawless person. We spent many hours at MDC. Mr. Combs recorded what I said. He didn't lose control. DOJ is responsible for MDC. Those phone calls of mine were constant. And I hung up, just thinking about what we are hearing here, the three. Returning to this issue, I believe that the judge is seriously considering allowing them to go out and trying to figure out how to do so, where the government's concerns are soothed to prevent media, to prevent that kind of misinformation. The difference a judge makes, there are many judges. I just heard Bradford's argument, all of it was great. They will listen and say thank you very much. There is a seat that was rejected. This is one of the judges who listens. one of the balanced judges, and the difference a judge makes. And he could, if not today, then on Monday, make a ruling in favor of Combs. Speaking of that, we have another update. Mr. Rico, again, his lawyer said that he accessed his mobile phone in MDC, but not under our conditions. The conditions: he fights, he kicks, he makes phone calls. This can be resolved. Thank you. The judge said that we will make a quick decision next week. Bradford. Yes, I think that's the smart thing to do. Listening to smart judges don't just make random decisions immediately. They go back to their chambers, they think about it, they have very smart clerks who know the law and provide them with rules to support their reasoning. And sometimes judges have emotional instincts after they've been on the bench for a long time, and lawyers too. We've been doing this for a long time, and you get an intuition about what's right and wrong, and then you have to find the case to prove you are right. I think that's really smart. I think smart judges make smart orders because they know they can be appealed, or they know it will be publicly read, and that's just what they do. So I'm not surprised that he didn't make a ruling right from the bench. Brian had said from the beginning that he wouldn't be surprised if the judge took his time and made a written order, because that's what good judges do. Good judges make written orders. They don't say things on a whim, and they don't automatically say one thing and do another. They think about it, sleep on it. And I don't know how many times I've been in a case where I felt like, oh my God, this judge is really, I feel like they're ruling against me. And they say, hey, listen, I'll make a written order. The weekend comes, they go back, read the rules again, find new rules, and then they rule in my favor for an entirely different reason, even one that wasn't discussed at the hearing. But that's what truly sets great judges apart from those who've been sitting on the bench for 30 or 40 years just going through the motions. They know what should be denied, what should be granted, and why it should be denied, and they're just, they're on autopilot. As I mentioned, when you have a relatively new judge, their perspective on certain issues can often be very refreshing. I agree that there's a very fresh judge. I think he is truly considering both arguments very carefully. As you just mentioned, the latest update is that he wants those letters by Monday. We'll make a decision next week. This could end by the weekend after being detained, we'll see, but the trial has been postponed. Gentlemen, let me say, Brian McMonigal, Bradford Cohen, thank you so much for your insights, analysis, and generosity in taking the time to speak with us. And I just want to leave you with one final suggestion. Imagine the two of you working together. Oh my gosh, how powerful of a team you would make. So let me end with this right now. Yes, you really should do that. Oh my goodness, that's such brilliant intellect that I've admired for a long time. I've admired Brian's work for a long time. And it's truly a pleasure to work with individuals who have been through the hard times, who have really handled cases that have been doing this for such a long time. Because we, the Warriors, generally think the same way, and it's always good to work with someone like Brian. That's my praise for you, my friend. All right, gentlemen, thank you so much. I truly appreciate it. Thank you, everyone. We will take a break for a bit. Elizabeth Milner will be leaving the courtroom, and she will give us direct insight into what she has observed, what she's seen about Sean, his family, and his lawyer. Stay with us on Long Crime. We'll be back right after this.